As we come to the final session of our conference, we shift our focus to a crucial topic, which is combating money laundering and ensuring the compliance of anti-money laundering regulations. Today, we are honored to have esteemed speakers who are expert in this field. Mr. R. Narayan Mohan, Senior Partner at Natarajan and Swaminathan, Chartered Accountant, Singapore. Sir, please welcome. A big round of applause, please. Next is CS Manish Ghia, Principal at Compliance Advisory Private Limited, Australia. Sir, over to you. Big round of applause. Thank you. Mr. Sanjeev Kathani, Lead Facilitator and Group Compliance at RV Group S Private Limited, Singapore. Big round of applause. Together, they will delve into the challenges and strategies in tackling money laundering, essential for maintaining the integrity of our organization and meeting stringent AML compliance requirement. Let's warmly welcome our speaker as they share their experience on this critical topic and explore the efficient strategies for combating money laundering. Thank you.
Good evening. I'm grateful to Institute of Company Secretary to address the wonderful audience who have come all the way from India. Also, people who are in India listening to the entire conference. My plan is this. I'm going to speak about 8 to 10 minutes about combating money laundering. My two distinguished speakers will follow me like that. Subsequent to that, we'll get it into a discussion and followed by question and answer. When you talk about money laundering, they say that we are experts. Nobody is experts in this world because it's one of the crimes people do. I just want to talk to you about briefly, what is Singapore? Singapore is a financial hub. All of you know about it. So I would like to give you a briefing about Singapore and then move on to money laundering issues. When I talk about Singapore, Singapore has been repeatedly awarded as ease of doing business #1. Presently, it is #2. New Zealand has taken over, but it's always #1 and 2 between Singapore and New Zealand. Singapore is the third largest financial center in the world after London and New York, and then third largest forex center in the world, again after London and New York. You may start thinking where the Hong Kong's position is. Hong Kong is the fourth in the world in both the situation. That's what I mean is in financial center and in forex center, Hong Kong is fourth in the world. The $4.9 trillion of funds are handled, assets under management in Singapore. More than 209,000 people are involved in the financial sector, contributing 20% of the GDP of Singapore. So that much make you understand the amount of volume of financial activities and financial transactions take place in Singapore. More than 500 world-renowned banks have established offices in Singapore. So any country you want to deal with, it's easy for you to deal from Singapore. There are no restrictions of money coming in and no restrictions of money going out. There is no capital control. Not only money and goods can come and go. Very few items have been subject to duty, like perfumes, garments, and leather goods. Other than that, there is no duty for most of the goods which are coming into Singapore and going out of Singapore. There are more than 11,000 Indian companies are established in Singapore. You can ask me what these Indian companies are doing. Their intention is to do global trading. They feel having an office in Singapore, most of the trading companies, you name the company in India, if it's a listed company, they will have a only one subsidiary established in Singapore. As I told you earlier, because of the RBI restrictions, they always try to have a only one subsidiary established in Singapore, and that company carry out the international trading operations. You can ask me how much of China companies and other rest of the countries' companies are established in Singapore. There are more than 6,500 to 7,000 Chinese companies are here, because they also have the opportunity to operate from Hong Kong. So they have the possibilities for them to establish in Hong Kong or establish in Singapore to do a global trading. The same way, companies from Korea, Taiwan, name the country in the world, each one has got like 500 to 600 companies established here. More than 7,500 multinational corporations, companies operate here, and 60% of them have got regional headquarters. What I mean by regional headquarters is from Singapore, they operate 16, 18 countries are reporting to Singapore because it's a regional headquarters for those companies. Now I move on to money laundering. I just want to tell you what is money laundering, because if I start going into combating money laundering, people doesn't understand basically what is money laundering. It's nothing but an ill-gotten wealth is been made to look as illegal money. There are three layers for that. They call it as placement, layering, and integration. Placement means physical disposal of the benefits of criminal activity. Layering means separation of these benefits from the source by creating intervening layers of financial transactions. And integration means this places the laundered benefits back into the economy so that they re-enter the financial system by appearing to be legitimate business funds. Now, what the Singapore government is doing to avoid, when being a financial center, the possibilities of crime is going to be very big. So what the government is trying to do. Now, I'm going to talk to you about Monetary Authority of Singapore have jointly moved with all the banks in Singapore and come out with a concept called COSMIC. What is COSMIC? COSMIC means collaborative sharing of money laundering, terrorism financing information and cases. Means the intention is they want to share the information among the banks in Singapore so that they can prevent or avoid money laundering activities in Singapore. What is the main criteria for that? Provide information to banks objectively if indications of suspicious or red flags transaction is going to happen. Focus on three key financial crimes in the commercial banking sector. One is the misuse of legal persons, the misuse of trade finance for illicit purpose, and the third one is proliferation of financing. What do you mean by proliferation of financing is where money is financed to do destructive things which is going to disturb the economy or countries in the world. Now, the COSMIC also intention is that complement the industry's existing close collaboration with MAS to strengthen Singapore's capability to uphold our reputation as well as regulations and make it as a trusted financial center. So these are the intention of this COSMIC, where MAS and few banks have joined together to exchange information. You can start asking me, are they going to exchange information in all cases? They don't have plans to do that. Their plans is only if they come across red flag situations, they are going to transfer all this information. Now I go into the second very most important thing, what ACRA is trying to do. ACRA is nothing but Accounting Corporate Regulatory Authority, which is equivalent to the Registrar of Companies in India. What ACRA is planning to do is they are going to come out with corporate secretary bill, because corporate service providers bill. Why this they are planning to do? See, most of the money laundering activities is happening through companies where they open bank accounts. So foreigners come into Singapore or foreigners sit overseas, request these people who are corporate service providers, auditors, to require them to open bank account, and these money laundering activities take place subsequent to that. I also told you in the morning, every company incorporated in Singapore, you need a resident director. So the resident director also, without knowing the person whom they are dealing with, open bank accounts on their behalf, take their instructions. Later on, they realize that they have been involved in a money laundering activity. In order to avoid all these things, what the government decided to do is to come out with corporate service providers bill, which I feel will come into law shortly within the second part of this year. Singapore has got more than 3,000 corporate service providers. You can ask me, in the morning you are talking about using a Sing Pass, you can form a company, that they are going to stop it. They are going to make only corporate service providers who have been licensed. Whoever is going to do any activity has to be licensed, so that either you file some document to Register of Companies, you should go through a corporate service provider. If you're going to appoint a resident director or a nominee director, you call it, it has to go through a corporate service provider. So the corporate service provider is going to see that the person is fit and capable to be appointed as a resident director for a company, for a foreigner who's going to request the corporate service provider to establish in Singapore. There are also amendments are proposed to the Companies Act and the Limited Liability Partnership Act to enhance the transparency of beneficial ownership of companies and a limited liability partnership. The bill will be required all companies or individuals providing CSS inland from Singapore to register with ACRA. The nominee directors' appointments are arranged by registered CSPs and assessed as fit and proper person by the registered CSPs. ACRA will supervise and enforce on any individual hold excessive number of directorship also. I'll tell you what is that. Previously, the CSP Act has not been announced yet, which has not come into force. Now today, anyone can become a resident director of any number of companies. The last one I read is one guy was a resident director for more than 980 companies in Singapore. So they feel that if you're going to be ruthlessly in more number of companies, the possibilities of you to understand the foreigner, understand the money laundering activities is not going to be there. So they want you to be very responsible. They have not come out with the figure. We do not know what the CSP, the new act which is going to come in, whether it's going to put a ceiling on the number of companies a resident director can act. But I feel that the monitoring by the ACRA on these number of companies where these resident directors are going to act will be very enforceable, whereby they will be restricting and then monitoring them very closely to understand that they don't exceed and they have the responsibility of being a resident director. Now I move on to the next issue is about, they also introduced recently an act called Precious and Semi-Precious Metals Prevention of Money Laundering and Terrorism Financing Act of 2019. You can ask me, what is the purpose of this act? This act, when you buy and sell precious and semi-precious stones, the possibilities of money laundering activities will be very high. So, this act was introduced. The act comes under the Ministry of Law. So, anybody who wants to set up a company in Singapore to deal in gold or any precious and semi-precious stones should take a license from the Ministry of Law. If you are going to have a 10 or 15 shops, each shop should have a license on its own. Also, there are two ethics which has been given to corporate service providers and also to the accountants like us, which is called Ethics 100 and Ethics 200. Under the ethics, they teach you about, they make you to learn about all the activities to avoid money laundering, how to handle a client, how to do the KYC for all the clients you are going to bring into the company. So, you're going to act and represent for those companies. So, when they are going to talk about the Ethics 100 and 200, they also come out with each company should have internal policies, procedures, and control. What do you mean by internal policies, procedures, and control? This gives clearly, if you are going to accept a client, if it is a corporate service provider or an auditor, if he is going to be a precious stone dealer, metal dealer, what he is going to do? He has to go through this manual to see that what is the process he has got to do the KYC of the customer he is going to introduce, what are the documents which he is supposed to keep. When you are going to recruit the staff for the organization, how you are going to recruit them, even for the staff you are going to recruit for your own office, you should do the KYC of those persons whom you are going to recruit. So this has been under the ethics 100 and 200. Our office have drafted this for the internal policies and procedures. which every company have to have in their organization. Now I move on to the next issue is about nominee director and resident director. There are a lot of cases that happened in Singapore, being the resident director and nominee director, they have assisted a lot of foreigners engaged in money laundering activities. Even today's newspaper, if you have seen it, one of the registered agent, secretarial agent, what they have done is that they have appointed a person as a director in the company without getting the consent from him. So the secretarial agent was penalized, and they also have been fined $6,500. But after the new act is going to come, which is I was talking about Corporate Service Providers Act, the penalty is going to be $100,000 for every offense where the corporate service is going to evade. It's going to be not only he loses the license, the penalty will be $100,000 for the offense. Now, the next one which I would like to talk about is red flag. See, the OECD countries, which represent more than 140 countries in the world, has got a financial action task force. The financial action task force make all the rules and regulations, make all the countries within the 140 countries to follow. So they have come out with red flag incidents of which has got what are the process where you have to be alert, and all those things are being informed. So the red flag is, the list is given by them, which comes within the 100 and 200 ethics which I was talking to you. If you'd like to have a copy of this, I will leave it to the corporate secretaries. People can pick up a copy of that, which are the indications of suspicious red flag activities. They also have come out with, the Financial Action Task Force also has come out with 40 recommendations where they say that you have to be careful in looking into all these 40 good things you do to see that you can avoid money laundering. Now, I will conclude myself to say that what is happening in Hong Kong, what's happening in Dubai. Dubai, Hong Kong, all these countries also have come out with strict following the the OECD countries financial action task force thing. Dubai has also come out from grey list also. So even it is difficult for you to, they have to comply with all the regulations. It is difficult to do money laundering in these countries also because of the regulations which they started following up. With this note, I conclude. I will come back to you again with all my co-distinguished speakers. I will request my speakers to take it up to speak, then we will get into question and answer later on. Thank you.
Good evening, everybody. I think Mr. Mohan has covered a lot of points in the realm of money laundering. I'll focus on incremental points. First, I want to talk about FATF. I think FATF is one of those very unique body across the world, which is the ownership of the entire AML regulations across the world. That's a body which has come out with recommendations and has pushed all the governments to make those regulations. I don't see that there is anybody else, an equivalent body, which enforces obligations on the governments to make those legislations. So, for example, if you see a flurry of new activities that are added to the AML rulebook, it is more a pressure of FATF. They have the mechanism of mutual evaluation of countries every 4 years or so. And if you fail that, you risk being put on the gray list. If you remember, probably a year or two back, there was that discussion in India as well. In Australia, we are going through that discussion right now because we're not compliant with some of the key recommendations of FATF. So it's a very unique body. And a lot of times there is no point in probably saying that, okay, why we are, for example, why company secretaries were covered, why chartered accountants, why lawyers, because that's the requirement of FATF to the governments and particularly the members. There are two sets of entities within the FATF which are regulated. One is the financial services sector, so banks, insurance, securities broking, and so on and so forth. And that all, I think, is more or less settled. They all are on their journey of AML that started, I think, around 2005-ish or so. The other set is called as designated non-financial businesses and professions. And that's where a lot of activity is going on, I think, in many jurisdictions across the world, including India, Australia, where businesses like bullion dealers or jewelers, precious metals, as he just mentioned, casinos, gaming, real estate agents, chartered accountant, company secretaries, lawyers. This is all, again, a universal phenomenon, nothing new. I mean, nothing specific to India, nothing specific to Australia, Singapore, whatever. Everybody is going through that journey. So those are also considered as gateway professions. Just to give a perspective, for example, in Australia, Australian Federal Police, in last couple of years, all the proceeds of crime that they have confiscated, 50% plus of them was real estate. And that sector is still not regulated under the AML. So that probably gives you a perspective why it's very important, especially in the Western world. The real estate has become a very hot asset class where a lot of foreign people invest and a lot of money laundering goes on as well through that sector. So that is one sector that goes under the AML and hopefully becomes cleaner. Reasons for CACS lawyers, because they are involved in setting up companies, guiding customers, and dealing on a range of business transactions and so on and so forth. So again, they have that obligation now to do the due diligence, asking the right questions, understanding the antecedents of their client. So I think in Australia, we are going through, for the DNFPBs, what is called as tranche 2 there. We are several years late to add that, and there is a risk of being put on the gray list. That's the discussion as well going on, but hopefully we'll not get there. And we'll have those sectors under the AML rulebook. Once those sectors are added to the rulebook, I think, if I may just put it in the context of maybe company secretaries, that, what's really the impact? You probably would have figured out that you have to get registered. You become a regulated profession, I would say. You have to have policies, procedures. You will have to do client due diligence and so on and so forth. But there is the other side of that as well. As you are regulated under the AML, you become part of the AML regulated entities ecosystem. There are many other businesses who will rely on you and will presume that you are doing all the activities which helps to reduce and prevent the instances of money laundering. I think there will probably come a time when financial institutions or your clients will ask you a certification that you have AML policies, you are doing training, you have a compliance officer, and so on and so forth, all the basic things required under AML. That is the kind of impact. So same thing, for example, real estate. Once it comes in, it is expected and it is presumed that overall risk of AML or money laundering will hopefully go down. So that kind of betters the whole ecosystem from a proceeds of crime risk or a money laundering risk. So that is the first point which I wanted to mention. So a lot of DNFPB is related and a lot of expansion of activities. And I think AML legislation or the money laundering related activities are not going to stop here. We now next have probably art dealers. We have dealers in luxury goods, or anybody who deals in things where value to volume ratio is really good. You can buy few diamonds and that could cost millions of dollars. It's very easy to launder money through that. Maybe those are the things which will next get into the realm of AML legislation. If I may talk about, I think one thing I just want to clarify is that the terminology that is used overseas versus India is slightly different. In India, we call them company secretaries or practicing company secretaries, which is what is the company service providers over, let's say, in Singapore or Australia, or even trust and company service providers. If you recall, there was a case of Panama Papers, And that was also an instance where accountants and company service providers did a lot of tax evasion, fraud, and things like that. And those were all money laundering related activities as well. So I think that puts things in perspective. The second thing which I wanted to mention was that since yesterday we have talked a lot of concepts here of ESG, DEI, and so on, so not so much as DEI, but AML is, or money laundering is actually part of broader realm now, which is called as financial crime. And that space is really expanding. You have anti-bribery and corruption there, you have modern slavery, you have human trafficking, you have environment, social, and governance issues. So the nice parts of ESGs have been discussed since yesterday. And if you go 180 degrees, what's really not been achieved, or are there intentional breaches of that, or bad practices, and they may lead to money laundering and financial crime. So always consider that. If I give example of Dali ship, which happened, the Baltimore incident, and there was this news report that the crew, the company which owns the ship has been found to be in violation of labor practices. Now, the crew of the ship is Indian, so maybe you have to ask a question, is that the company which is our client, and have we done a due diligence, that what do they look like? Are these the things which are coming out when you take a call on the quality of the client, his antecedents, or his practices and all that? So I think a lot of such global events, or events even within the country, has to force you to think of your due diligence of those clients which are kind of connected with you. So as I said, so a lot of such events, so that could be an instance, for example, of modern slavery, again, of that Dali ship, if there are issues about, for example, underpayment of dues, or working beyond reasonable hours, and things like that. Another example I can give is that Australia recently updated its foreign bribery laws. Within that, in the scope of the foreign bribery laws, what it essentially says that if an Australian entity is caught bribing a foreign public official, it would be open to prosecution. Now, who is subject to prosecution? The company, of course, the Australian company, and its associates. The associates is such a wide definition. If there is a service provider in India to that Australian company, that service provider, Indian service provider, is an associate of the Australian company. And if something has gone wrong, either at by the company itself or by the service provider, the Australian company is responsible. So I think that's the point I'm making, that is the realm of financial crime is so big now. You have to really think of several other issues apart from money laundering as well. Just putting before you some of the enforcement actions. I think, again, globally, that's a trend which is catching up and speeding up. There's a lot of enforcement actions, a lot of penalties, a lot of orders. I think in India, Paytm has become one big case where the company has been practically shut down because of the KYC violations, an unprecedented event, I would say. I remember reading that statement of Mr. Vijay Shekhar Sharma that henceforth compliance would be my biggest priority. Too late probably to say that. In Australia, for example, Westpac Bank was fined $1.4 billion. They failed to file several hundred thousands of reports on foreign transfers, which was due to some software issues and things like that, but nothing doing. The chairman, the CEO, they lost their jobs. And related to that then is the reputation issue, which is a risk which everybody carries. Maybe actually the bigger companies have a bigger appetite to weather that reputation risk, but for smaller businesses, once your reputation is gone, most likely you're not going to get it back. So I think that is another risk within this realm, and that's why it is important to have a really robust AML-related procedures and policies. And not just that, there is sanctions as well. Now, if you are, for example, just doing activities in India, it may be less of a subject, but globally, again, it has become a very big subject, especially after the Russian war. And so, yeah, that's all I think for the moment I have to share. Yeah, thank you.
Don't run away. I still got some time. I know you all are tired, you want to go home, right? I also want to go home, so I'll make it chop chop and chop chop. Okay, my two esteemed speakers have spoken a lot, so I just want to add 3 points. Right? When we talk about money laundering, it is not something that was born yesterday. It was there when I was born and way before that. Right? It's just that of late, things have become more exciting, especially in my country. Right? I'm from Singapore, so it got more exciting, right? And how did the recent money laundering case uncover? I can only share at the highest level because this is being recorded, and I will tell you what has happened. And then the other 2 things I want to share with you is that at the end of the day, the institution would have to look at the triple R, right? The triple R is basically your appetite, your capacity, your tolerance. Are you willing to take it? There are banks, I think all of you know, in Singapore, they shut down accounts overnight of corporates, right? After the pressure from FATF, the Financial Action Task Force, and no reason given. They shut down, right? There is a lot of pressure on the banks as well to do, right? So you look at your triple R. Then the other thing what you need to look at when you look at money laundering, you need to look at CS. CS is not company secretary. Before you all start getting excited, anybody knows what is CS? You all are very smart people. I'm sure somebody knows the answer. No. Thank you for trying. I will give you a present later. CS means common sense. The problem today, when people do AML, they don't use common sense. Right? That's a huge problem. The other thing that you need to know when you do AML is husband-wife theory. For all of you who are married in this room, blissfully married, you all will know wife is always right. Husband is never right. Don't come and argue with me on this point because I have been proven right. Okay? I married and divorced the same woman twice. Okay? So I'm a proven living testimony of it. So when I say husband-wife theory means the 5W, 1H. Where, what, when, why, who, how. If you can answer these questions when you're looking at a transaction or a deal, then you're not really going into the crux of what AML was intended to do. Right? So very important, common sense. And remember, common sense is not so common today. And husband-wife theory. Okay. Then, lastly, before I sit down and keep quiet, is in Singapore, how did we uncover this miraculous case? Right? And we became in the spotlight of the world. Right? Now, this was something that was happening for years. It's not that it was not happening. But there was, like what my fellow speakers have said, collaboration between countries, between banks, right? That's how they uncovered. And normally when people do money laundering, they try to do, they always leave traces behind, right? They make the silliest mistakes. And today, they got caught. And of course, the case is ongoing. And money laundering, there are many, many ways to do it. Like Sir spoke about precious stones, metals, jewelry, diamonds, blah, blah, blah. It's all there. Real estate. The bigger one is art. It's very easy to launder it through art. Okay, but that's another topic for another day. In the digital world, it's even easier to do now. With crypto, with Bitcoin, with God knows whatever that you have, it is fascinating times for all of us. But again, please remember, come back to CS. Everything is coming down to common sense and the 5W1H. So with that, I keep quiet. We take question. I think that's more exciting than me talking down here. Okay, thank you.
Yeah, what I would like to say, a few things, before we get into the question and answer section. There is a suspicious transaction reporting office in Singapore, which is attached to Commercial Affairs, CAD, Commercial Affairs Department. There are more than 45,000 cases are reported during the past few years. It may increase in future. Out of these 45,000, maximum comes from banks to the suspicious transaction reporting office. Can you guess who are the rest of the people? Money changers, auditors, and corporate service providers. So they are also having lot of complaints coming into them. It is difficult to open a bank account, not only in Singapore, it's also difficult to open a bank account in Dubai or Hong Kong, anywhere in the world. Even you set up a company, easy to set up, as we all discussed, even in an hour's time we can set up a company. But to open a bank account is very, very difficult to do today. So that's why I always, any clients walk into our office and say, I would like to set up a company in Singapore, I tell them first go and talk to the banks. You are already dealing with few banks in India. If these banks have got offices in Singapore, go and talk to them, see that you get the bank account open for you, then we can form the company and pass it on. I would like to tell you one or two questions and take the questions from the floor. My panel also will answer along with me. First question is that, what are the different types of problems faced by financial institution and suspicious activity reporting? What are the problems faced by the financial institution? I will answer you first, because now the cosmic which has come, the concept is that where sharing of information between banks and Monetary Authority of Singapore will enable them to reduce their difficulty in making the report, because the information will be shared for red flag activities. I was telling you, they are not going to share the information like that. When there is a red flag activities is involved, they are going to share the information which is facilitate them to reduce their problems. If anything else you want to add, please add on, please.
I'm not sure that there is difficulty per se in filing the report itself. I mean, it is more the previous processes which really leads to that result. So how strong is your policies and procedures? How strong is your due diligence? I think Sanjeev mentioned about 5 Ws and H. How strong are you in asking those questions? Open searches, sanction screening. Have you been able to do all those things really well? And in case of larger transactions, have you asked the right questions? Do you really understand? Because in AML, they always say, understand the customer and follow the money. You know, have you really been able to understand that? And if your gut is saying something is not right, then maybe there is a suspicion. You need to follow up on that by filing a report of suspicious transaction. Now, yes, there are certain rules. Regulators have expectation in terms of the quality of report, especially when you are narrating. I'm talking more from an Australian context, that when you're narrating what was really the background of the matter. And regulator expects you that you really put that succinctly as well as in detail so that they understand it without really coming back to you with follow-up questions. There could be technology aspects of this question where in bigger organizations, hundreds of reports are there. And are you taking support of technology to file those reports and things like that?
Thank you. Thank you. You can go ahead.
Okay, so I just want to add a couple of points here, right? I think it's not difficult to file. That's the easy part. The problem is when you're dealing with high net worth individuals or ultra high net worth, or dealing with companies that have got muscle power, where you as the FI have a tough time. And like what Sir said, asking the right question, because no question is stupid, right? But the problem is when the frontline people are facing, right? And when an ultra high net worth is there, they literally like stand frozen, like frozen. They just don't know what to do. So it's very important that when you're doing AML at the front line, your people also understand human psychology, because the eyes give away a lot, right? And don't be so fixated, ladies and gentlemen, on documentation. In my humble experience of half a decade, documentation only tells you what it wants to tell you and nothing more. What documentation you want, I can give it to you, right? So please take a step back and look beyond documentation. So that's what I want to share. Thank you.
Thank you. I go to the next question, and then I take the questions from the floor. The next one is, how can training programs be designed to effectively equip corporate service providers with the skills and knowledge to identify financial crimes? I will answer first and then let them take it up. See, when I was talking about Ethics 100 and Ethics 200, which is a requirement for all corporate service providers, accountants to know about it, if you're going to recruit a staff for any of these organizations, you have to brief them about Ethics 100 and 200 to them when they are coming into the organization. Prior to you yourself checking on the basically the due diligence on the staff which is going to come in. Subsequent to that, before they start working in the organization, brief them about Ethics 100 and 200, make them to understand all these red flags activities and also the FATF 40 recommendations, and also run down the Ethics 100 and 200 to them. You can take it up.
So for training, right, again, what Sir said is very correct. But my view about training is that it's not one size fit all, right? I've been to many organizations where they say, yeah, they did AML training, everybody attended, took a screenshot, and that's it, done. I said, what was discussed? The slides. I said, how do I know that even they understand? Oh yeah, there was a quiz, but it was a verbal quiz. I said, excellent. Then when you talk to the staff, you know that they did not understand anything. So I think it has to be bucketed training, where depending on the level, you would pitch it. And from my humble experience, training has to be interactive, exciting. No one wants to listen, to a training that is boring. And I'm sure all of you have attended many in your lifetime, right? So either you gamify it, and you have to show people what is the benefit for them for attending the training. Because if they cannot see that, it's switch off, right? So that's my view.
Okay, I would like to add more. Sorry, I would like to add something more. The training should be continuous also. Means every 6 months or 1 year, you have to update them. Not only the existing staff, you have to keep on informing them. When the new staff comes in, they sit along with the old staff to see that they are being trained regularly. Second thing I want to tell you very interestingly, when the new act came into force about the precious and semi-precious metal, I have gone to various jewelry shops. The shops open at 9 o'clock. I have told the bosses, keep all the staff to come at 8 o'clock, keep the shutter closed. 8 to 9, I was briefing them about all these requirements of these internal policies and procedures book, which I was talking about how to do the due diligence for the customers. They are going to come in, how to get the passports particulars. If they are going to deal, there's a provision in the Precious Act. If you're going to deal with more than 20,000 cash, you have to make a suspicious transaction reporting office. Or if the person is going to split the purchase into two on the same day, so that it doesn't exceed 20, again, you have to report to the suspicious transaction reporting office. So all these things I was training them, doing 8 to 9 when the shutter was closed before the shop opens at 9 o'clock. You can add to now. Anything else you want to add?
Just to add to that, I'll say training also includes awareness programs, self-development programs, and so on and so forth. And one is what is done inside the company. So basic programs are there, of course, but it also has to be role-appropriate training programs. Not every role is same and cannot have the same training program. So that is very important, and it's a regulatory expectation as well. Equally important is the external training. So to give an example from Australia, when the crypto exchanges were added to the rule book, the regulator itself did a lot of outreach program with the industry and people who are going to be part of that industry. That is also extremely important to train, to develop awareness, as well as to drive the point. I'm part of ACAMS in Australia, and we do several programs for the financial crime community, and OSTRAC, the regulator, does outreach programs with us. So there are whole levels and whole different stakeholders who are there, who are part of the training ecosystem. It's important to leverage all of them.
Thank you. I've been asked to close at 4:30 sharp. I'm ready to take questions from the floor. If you have any questions to ask, feel free to ask. You have 7 minutes to take it up. If you don't have any, yeah, go ahead. Any questions?
I'm sure somebody has a question, no? Can't be, nobody has a question.
Is the subject is complicated or?
Oh, we are too good. There are only two possibilities. I'm sure my friend there, Mr. Silas, got a question.
Yes, yes, please.
I got a question for you, sir.
Sir, how technology can play a role in anti-money laundering compliance? Like what we can use, like machine learning or something like in financial institutions. What technology can be used to mitigate the risk of money laundering?
Absolutely, very interesting. See, what has happened is there's one Indian company has created a software, because humanly you cannot go into the transaction to find out the money laundering activity. So the one Indian company which I've seen have created a software where, if usually in money laundering they transfer the money to 50 accounts and 60 accounts. So this software can identify these type of suspicious transaction, make the bankers to be aware, to go in to look into this type of transaction, to find out any money laundering activities is taking place. Anything else you want to add?
Yeah, so technology, right, it's only helping you. Don't become a slave to the technology. And before that, like what earlier on, I think the speaker spoke, the data integrity that goes in there, where you're using it to check against, you have to check that, and garbage in, garbage out, right? So you need to be very careful what you are doing it for, right? Because technology will only help you to a certain extent, right? You cannot just rely on it and say, yeah, that's it. When the technology gives you a report, human still has to come in and analyze it, right? So to me, that is very, very important.
Anything else? Any other questions? I'll just add to that. Yeah, please add.
So I think there's also some nuances to technology question. For smaller entities, maybe technology may not be the answer, because if your volume is not such or you can't afford, then that could be something which is manual. But for bigger companies, you cannot do without technology. And it is at every step of the way, right from customer onboarding, doing KYC, to alerts management, to transaction monitoring, and coming to suspicious. Of course, there are human elements have to be involved. So technology definitely has a very, very important role. It's a regulatory expectation. If you're a large bank, you don't have technology, you definitely cannot go anywhere, and regulator is not going to accept your position. The other thing is AI is coming in a big way, and we were discussing AI this morning. And I think you have to remember that eventually you are responsible for your compliance. If you're putting AI models, you have to ensure that they're adequately trained, they have really right decision-making system within them. They are not taking wrong decisions, biases and discriminations, even that, when you're looking at transaction monitoring, customer profiles and things like that. So you have to be just careful of that as well.
Yes, please. Your question, please.
I just want to clarify, like, to do sanction due diligence is quite structured in the sense that you can refer to OFAC, UN, or EU platform to check a party whether are they sanctioned. But for money laundering, is there any platform that we can refer to that you can bring up the red flag? Right, according to Mr. Sanjeev, just now you are saying, for money laundering, you have to basing on common sense and the 4W1H, right? So, but that one is still very subjective to the person, right? It is still very person dependent. So my question is that, is there any other platform that we can see any red flag, and then any other technology that it can help us to eliminate the human interpretation?
I've understood. What you're talking about is even Thomson Reuters says he's a gentleman. The gentleman get involved in a money laundering case. Only AI has to help us in future. So we wait for the AI to help us, even for a gentleman where the Thomson Reuters or any of your such doesn't reveal that he's a guy, bad guy. But the guy is going to do a money laundering activity. We have to wait and see whether AI is going to come to help us that in future. Anything else you want to add?
Just on the sanctions bit, I partly agree with you. Yes, it seems very simple. You check in the sanctions database whether or not somebody is listed there. But there is also a world of, let's say, trade-based money laundering. There are shipping companies related trade and things like that. There the sanctions gets really complicated because there are several parties involved, several jurisdictions involved. There are agencies who specialize in helping you evade sanctions. You can read that. If you Google evading sanctions, you'll get many articles on that as well, especially after the Russian sanctions, how you can evade those sanctions to still trade with Russia. You know? I think it's not very simple for some part of the businesses.
Even after doing the person search, we also do Google search also to find out anything else comes up in the newspaper, any articles on the person concerned. So we do both in our organization. Anything else you want to say?
Yes, so my friend, what I just want to add to what they've said, there is technology, there are platforms where you can use. I can share with you, right, offline, and because I'm doing one now where, you know, it just gives you, but then you have to take it with a pinch of salt and pepper, because again, the human comes, so ultimately you got to know what is the normal to find the abnormal. The problem is nowadays we don't define the normal, and then we don't even know the abnormal, because the world has become VUCA, right? Because nothing remains the same.
It's 4:30 already. Any pressing question? Yeah, the last one. Then I conclude. Please go ahead. Please go ahead.
Typically in an organization, who we can consider responsible for carrying out the anti-money laundering checks?
No, you should have a suspicious transaction officer in every organization.
Okay.
The regulations requires you to have an
Compliance officer. Compliance officer, suspicious transaction officer. They all to be appointed.
Then the following question will be, what is the key information a compliance officer can ask for that kind of a transaction?
No, he has the right to go through all the information. And then to see, usually the persons who manage the company will not be a compliance officer or a suspicious transaction officer. Some other senior people will be appointed of independency. So that the management, if you are the managing director, I should not be the compliance officer, not the suspicious transaction officer. It should be somebody else in the organization for independent activity in the company.
So can we say the risk management committee can also be considered?
Yes, absolutely, absolutely.
Sorry, not committee. Committee is not an officer.
Well, individual should be an officer.
An individual person.
Individual person has to be an officer.
These are very established norms, and for any organization which is regulated under AML, they have to have an.
And also the objective of the roles to be played has to be clearly mentioned also. What's the role of the compliance officer also?
Okay, thank you.
Thank you, thank you, thank you, thank you.
I trust everyone found our session with our esteemed speakers both enriching and enlightening. Their insights into money laundering in Singapore, the significance of corporate service providers in Singapore, importance of awareness of local nominee director, proper onboarding and KYC process, and red flag indicator of money laundering were very useful. As a gesture of our appreciation and our privilege to present them with mementos, I kindly request Mr. Dinesh, Vice Chairman of ICSI Singapore Overseas Center, to come and offer mementos. Big round of applause, everyone. Thank you.
Thank you, madam.